Hello, everybody. This is Brian. Welcome back to Brian's Government Audit. I like to say that because I like to expose what the government is doing to all of you. And I've been making probably the last two videos is the constitutional man, Carl Miller. He's exposing, not only exposing, but he's showing you exactly how to go to court. You don't need lawyers. You just need to know the Constitution and go to the library and read a little bit about law. And he's going to tell you exactly how to read it, exactly how to put it together to win your cases. Now, he started out, when you start out doing this, I'm sure it's not going to be perfect. You're going to be scared and all that stuff. I get it. But being prepared is the best way. And believe me, getting a lawyer is basically, that's why they do that, because it's very expensive to get a lawyer. You're better off just to go represent yourself. Who knows better about the cases? You. So here, this is going to be part 3, and this stuff is good. So take notes.
Now, the next case we want to talk about is Briers versus United States. We mentioned it previously earlier. Briers is recorded at 273, volume 273, U.S. Reports, page 28. Okay? Now, Briers versus United States is a unique case. It's a search and seizure case, but basically it sets constitutional standards which we had talked about in the am jurisprudence sections. Okay? I especially want to pay attention to note number 3 here. Constitutional provisions for the security of a person and property are to be liberally construed, and it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachment therein. All right? When a federal officer participates officially with a state official in a search, so that in substance and effect it is their joint operation, the legality of the search and the use and evidence of the things seized is to be tested in federal prosecutions, as it would be if the undertaking were exclusively the federal agent, all right? The reality here is what they are setting is the standards must be liberally construed in favor of the citizen. It's the duty of the court to make sure that happens. So now you have a right to be wrong. You have a right to enter your viable defenses that you honestly think. No state can convert that right into a privilege and issue a license and a fee. If they do, you can ignore the license and the fee. They must prove the burden of proof of willfulness, which they cannot do. If they do violate your rights, you do have a right to sue them in Owens v. City of Independence and Maine versus Thibodeau. They have to give every consideration to you, all right? And that's the way it is. 1900 yesterday, all right? The next case we want to talk about is Boyd. Boyd versus United States, 116 U.S., page 616. The court is to protect against encroachment of constitutionality or secured liberty, all right? Now, it is equivalent to a compulsory production of papers to make the non-production of them a confession of the allegations, which is pretended they will prove. And a lot of times that happens in federal cases. They'll claim something, they won't prove it. That's happened to me, believe me. And then the fact that they've claimed it makes it true. And then, of course, you have to prove a negative, which is impossible. All right? Now, the seizure or compulsory production of a man's private papers to be used in evidence against him is equivalent to compelling him to be a witness against himself in violation of the Fifth Amendment, and in a prosecution for a crime, penalty, or forfeiture is equally within the prohibition of the Fifth Amendment. See that? Now, the bottom line here is Boyd protects against encroachment of constitutionally secured liberties. That's arguing the Fifth Amendment here, but it's basically arguing against encroachment, all right? So that's one you want to pay attention to when you're coming, especially to things on search and seizure natures. Another good case that you should know is your Miranda versus Arizona. And folks, I'm going to tell you something, and even I can learn something. Not that I'm that much above you. I want to come to you humbly, in humility. I'm telling you, I've read and I know, and there's a lot of things about the law, and I've been my own attorney for over 25 years, and I kick the tail out of them, I'll be honest with you. But I always can learn something, and I'm not stupid enough ever not to realize that. And the next thing I'm going to tell you is probably one of the most important things we're going to tell you today. This is the Miranda versus Arizona decision. It's recorded at 384, volume 384 U.S., that's U.S. Reports, page 436. Now, this is a heavy-duty case. Every American should know this case backward and forward, upside down, and other. All right? Miranda versus Arizona. This is the one that says you got a right to remain silent, you got a right to an attorney, you got a right to have your attorney present during questioning. Anything you say can and will be held against you in a court of law. If you can't afford an attorney, one will be appointed for you by the court. Do you wish to make any statement on your behalf? Do you understand the rights that I have spoken to you? As soon as they stop you, talk to you, as soon as they start talking to you, they are required to say that. If they don't say that, they screwed up. If they haul you into jail and they don't tell you this, read it to you, and then they want to make you sign a little statement that you know your rights and you knowingly waived them, please, folks, don't sign that statement. Use your head for something other than a hat rack. Do not sign that statement, ever. You are knowingly waiving your constitutional rights. Don't ever do that. I mean, they don't make it that hard. As soon as you hear those people start talking that, you tell them right effectively, I want to talk to an attorney. And I'm not saying nothing until I talk to an attorney, especially if you're talking to federal people, BATF. These people will lie, cheat, steal. They will do anything they can to hammer you. Their whole purpose in life is to hammer you. I don't want you to think, oh, what nice guys. So maybe we can just work this out. Why don't we just talk and maybe we can get things worked out? You don't talk to these people, folks. And you're talking to somebody who learned the hard way. You do not talk to these people ever. I don't care if you think you're a nice guy and you want to be courteous. I don't think you think if you're going to work it out. I don't think you think if you're smarter than they are and you can beat them. I'm telling you, you don't talk to them. Period. You button that hatch. An old wise legal defense counsel told me one time, he said, the first rule is keep your big mouth shut. I said, okay, what's the second rule? Keep your big mouth shut. He said, what's the third rule? Keep your big mouth shut. He said, after you follow them 3 rules, the rest is easy. It's when you open your big mouth that you get in trouble. Not that you would do anything wrong anyway, but they'll twist, lie, cheat, and steal and make it into something you didn't do, and before you know it, you won't even recognize what's happened. And I'm telling you, it's happened to me. So I'm telling you as a friend. I'm not telling you as a smart ass or anything else. I'm telling you as a friend. Do not talk to these people. They do not have your best interest at heart. And you may think, well, they're the government, and they're responsible, and they mean well. Well, they don't. They don't mean well. They don't mean your well, and they will jam you, believe me. And if you're not real good at getting out of it, you can be in a lot of trouble. All right, now, let's look at this Miranda decision. In the absence of other effective measures, the following procedures to safeguard the Fifth Amendment privileges must be observed. The person in custody must, prior to interrogation, be clearly informed that he has a right to remain silent, and that anything he says will be used against him in a court of law. He must be clearly informed that he has a right to consult with a lawyer, and to have a lawyer with him during interrogation. Do that, please. And that if he is indigent, a lawyer will be appointed to represent him. All right? If the individual indicates prior to and during questioning that he wishes to remain silent, the interrogation must cease. If he states that he wants an attorney, the questioning must cease until an attorney is present. Where an interrogation is conducted without the presence of an attorney and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his constitutional counsel right. Don't test that theory. But I'm telling you, it works. I did it. Where the individual answers some questions during interrogation or custody interrogation, he has not waived his privilege and may invoke his right to remain silent thereafter. The warnings require that the waiver needed are, in the absence of a fully effective equivalent prerequisite to the admission or admissibility of any statement, inculpability or exculpability made by the defendant. The limitations on the interrogation process required for the protection of the individual's constitutional rights should not cause an undue interference with the proper system of law enforcement, as demonstrated by the procedures of the FBI and the safeguards afforded to other jurisdictions. In each of these cases, the statements were obtained under circumstances that did not meet constitutional standards for protection of the privilege against self-incrimination. Now, this is the big one, folks. This is the one they're talking about. Did you properly Mirandize him? Was he Mirandized? Was she Mirandized? If they don't Mirandize you, they got to throw the case out. Almost always. It's very hard to go forward with the case if their witnesses are excludable from the presentation of the case. Now, I personally got lucky on this one, folks, and I thought I was really, really good, and I am really, really good. But you want to know something? I have a different standard of equity and law, and I treat everybody kindly, and I basically give them courtesy, and I basically try and be a regular Joe, and I basically just find out what the heck was going on with this case. I promise you I would never do that again. I would dummy up like there's no tomorrow. I wouldn't say nothing. Not that I do anything wrong, but here's the thing. These people lied so bad. They put so much trash in the record. I was in shock. I couldn't believe that anybody would deliberately do such a thing. But they will. So I'm telling you as a friend, do not talk to these people, especially BATF people. They are not honorable people. They do not recognize the honor you serve. They are not honorable people. Their whole purpose is to hammer you into a position of ridiculousness. So I'm telling you, if they come in to talk to you for whatever reason, I don't care what, you dummy up. You don't say nothing. You got me? You hire an attorney. You get an attorney there, and you don't talk till the attorney tells you to. And that's what I'm telling you as a friend, okay? It's Miranda versus Arizona. Now, there's 4 Miranda cases. This is the leading case. There is a Miranda warning case that actually locks down the steps of the warning. And then there's a Miranda interrogation case, which locks out the standards for in-custody jail interrogations, okay? Now, a word to the wise should be sufficient, and I shouldn't have to ever say nothing about that again. Believe me, I learned a valuable lesson. You cannot assume that everybody is a good guy. There are some bad ones out there, and I found them. Now, the next case we're going to talk about is Norton versus Shelby County, recorded at 118 volume, United States Reports, page 425. Basically, that says an unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protections, it creates no office. It is in legal contemplation, as inoperative as though it had never been passed, okay? And that's what this case holds, all right? And now, I'm telling you, you go read the case. Don't screw around. The judge asks you questions about the case. You better know about what it says, all right? Because if he thinks you didn't read it, he's going to throw your case out. The court follows the decision of the highest court of the state in construing the Constitution and the laws of the state unless they conflict with or impair the efficacy of some principle of the federal Constitution or of the federal statutes or a rule of the commercial or general law. The decision of the state courts on questions relating to the existence of its subordinate tribunals and the eligibility and election or appointment of their officers and the passage of its laws are conclusive upon federal courts, all right? Now, some of the most important thing is, while acts of de facto incumbent of an office lawfully created by law and existing are often held to be binding from reasons of public policy. That's a very important point. Public policy. You want to watch out for the terms public policy. It's often confused with the state's right of eminent domain of police powers. Police powers and public policy are almost the same thing, except one's done without law because we wants to, and the other is done because they're claiming a police authority to do so. All right? But when they're talking about public policy, the acts of the person assuming to fill and perform the duties of an office, which does not exist, can have no validity whatever in law. Okay? An unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Okay? Has everybody got that? Now, this basic first portion of this program is designed clearly to help you. And if you take these basic cases on this one page, you will have gone a long way in getting your constitutional rights back. Okay? Now we're asking you, pay attention. Learn your Constitution. We're going to go into some heavier stuff through the second portion of it. But we want you to learn your Constitution. This book here is a citizen's rule book. It also has jury instructions in it. It also has a lot of important arguments in it. Some of the important arguments in it go along with what we've been talking about. All right? All laws which are repugnant to the Constitution are null and void. Marbury versus Madison, 5 U.S. 137. We already argued that. When rights secured by the Constitution are involved, there can be no rule or lawmaking or legislation which would abrogate or abolish them. That's again Miranda versus Arizona. An unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protection, it creates no office. All right, that's Norton versus Shelby County, which we just talked about. The general rule is a non-constitutional statute, though having the form and name of law, is in reality no law, but is wholly void. All right. 16th Am Jurisprudence, 2nd Section 177, and also 256. Officers of the court have no immunity when violating constitutional right from liability. That's Owen versus City of Independence and Maine versus Thibodeau. No state shall convert secured liberties into privileges and issue licenses and fees for them. Murdoch versus Pennsylvania. If the state does convert liberty or privilege into a privileged citizen, can engage in right with impunity. That's Shuttlesworth versus Birmingham, Alabama. The court is to protect against any encroachment of constitutionally secured liberties. That's Boyd versus United States. Constitutional rights must be interpreted in favor of the citizen. That's Byers versus United States. We have covered all of these cases thoroughly so that you can see clearly. All right? We're trying to teach you how to better effectively use your Constitution, okay? We're trying to get it down to a serious program. And this book here also brings out all these court cases, right? Notice it's got Norton versus Shelby County in here. It's got Miranda versus Arizona. It's got Madison by Marbury versus Madison. It's got the jury has a right to judge both the law as well as the fact. John Jay, First Chief Justice, U.S. Supreme Court. The jury has a right to determine both the law and the facts. Samuel Chase, U.S. Supreme Court Justice, 1796. Singer. All right. The jury has the power to bring a verdict in the teeth of both law and fact. Oliver Wendell Holmes, U.S. Supreme Court. The law itself is on trial quite as much as the cause, which is to be decided. Harlan F. Stone, 12th Chief Justice, U.S. Supreme Court. The pages of history shine on instances of the jury's exercise of its prerogative to disregard instructions of the judge. That's United States versus Doherty, 473 Fed 2nd 113. All right. Now, we're going to wrap up this first part here. Basically, we want you folks to hopefully not be overwhelmed. Take your time. Play the tape several times. It'll come to you. It's really not that hard. We want you to have a new reverence for your Constitution. We want you to know that a lot of brave soldiers paid for it with their life. We want you to know that they died miserably, some of them. And we want you to know that this is a serious, very serious thing here. We want you to know that we love you, America. And we want you to know we need your help to learn your Constitution so you can better and effectively come forward, pick that book up, walk out there and shake that book and say, "Shaking it, boss." All right. Now that we've gone over the Constitution and we've talked about some of the ways that you can use it, now we're going to go into some of the ways that you can apply it, okay? The things to do, first of all, is when you pull over, try not to demonstrate any rapid movements or any, like you're reaching under the seat or you're reaching in the glove box. Keep your hands where you can be seen. Do not overreact. Try and be calm. Talk to the officer in a mellow voice. Don't yell or holler or use profanity whatsoever. Basically, it's yes, sir. What can I do for you, sir? They'll usually ask you to produce your documentation. You have license, proof of insurance, and the registration of the vehicle. Okay? Now, we're going to go into a lot of issues on those programming to cover that, to show you some of the things that you can do and what you can opt to do. Also, I recommend that you treat the officer, as I told the other gentleman there, very courteously, because that is going to get you a lot farther ahead than giving them a lot of negative hype or trying to outshout them or give them a lot of static. So my honest counsel is, let me show you how we proceed. Most of the time, you will be able to leave the scene without any serious injury. You might have a ticket or this or that, but we'll show you how to deal with that, okay? But you need to be understanding that this party is an armed party, and you don't want to do any movements that's going to cause him to overreact to an injury of you. Yeah. And you'll find that a lot of times this is the most dangerous thing a police officer does, is stop people all day, because he never knows when somebody might do some really serious traumatic thing, So they're very nervous about this, and the quicker you can relieve their nervousness and just be a regular person and let them realize you're just going to talk in a plain and common voice, the sooner you're going to be in a communicative situation. Now, obviously, you're going to find out real quick if you got a cooperative officer or not. If you don't have a cooperative officer, then you're going to be in court anyway. So the best thing I can tell you is be patient. Just let us follow along with our program, and we'll be happy to demonstrate. And again, we would like to let you know that your best defenses are in your Constitution, that Constitution is a viable contract, that it is enforceable in the court of law under the statute of frauds, that you have a right to claim those rights, that the burden is on you to claim them timely, and a key word here is timely, or you lose the right. So you want to be cognizant of your rights and be able to timely speak up, okay? So let's go on to a couple of things here. We're going to concentrate, as we did before, on our main basic cases. We also want to give you some further advanced programming. The book, The Federalist Papers, by Madison, Hamilton, and Jay. Those are the gentlemen that wrote the United States Constitution, okay? And you want the Mentor edition because it is the unabridged edition. Now, the Supreme Court has ruled in the case of Cohen versus Virginia. That's recorded at 6, Wheat Reporter, volume 6, page 2, all right? Now, Wheat is an old report, and this was done in 1821, so you may have to go to your leading law library around, like we go to Michigan, University of Michigan, or we go to Detroit College of Law, but you want these pages will be so old you'll have to worry how you turn them without trying to screw them up. But the Supreme Court ruled in the matter of Cohen versus Virginia, 6 Week 2, that this book, The Federalist Papers, was the exact record of the intent of the framers of the Constitution, Madison, Hamilton, and Jay. Those are the guys that wrote the Constitution. So obviously being able to read their published thoughts as they were doing this Constitution is very, very forceful in terms of constitutional interpretation. And the intent of the lawmaker is the law. And it shall be liberally enforced in favor of you. You are the clearly intended and expressly designated beneficiary, got me? So everything you can do to enhance your position in terms of how your lawmakers thought when they framed this Constitution clearly makes your case even more stronger for the Constitution to be interpreted in favor of you. So we recommend you get a copy of this Federalist Papers. You read it cover to cover. You want the Mentor edition because that's the unabridged edition. You'll find some of the other editions got some of the pages pulled out, okay? Now, we want to get into some of the cases. Basically, the second program that we have here is the advanced section. We are going to be covering procedures. We're going to be teaching you how to be your own counsel. We're going to be telling you some facts and issues on what to do, what happens when you get pulled over, how do you exercise your rights in a timely fashion. We're going to be talking about some of the problems that are going on in America today. We're going to be talking about some of the studies that have been done. We just had a law review study put out by this lady here. Her name is Joyce Lee Malcolm. Joyce Lee Malcolm. She started out working for the anti-gun people. She is a Harvard legal scholar. She is very, very knowledgeable. She researched the right to keep and bear arms of the people back to the 1700s in England. And she came to the honest belief after all of her research, and of course she would be following her research because she is a person of very acclaim in terms of her study. She researched it back to the 1700s and found out that, yep, our right to keep and bear arms is a positive right. It has come from serious law all the way back to the Magna Carta. She published a book, and the book here is To Keep and Bear Arms. It's a rather extensive book, okay? It's not hard to get a hold of. It did take us about 10 days of ordering it to get a hold of it. But it's a definitive study on the right to keep and bear arms that verifies the holdings that your average person who's NRA oriented or who basically is constitutionally oriented is going to be happy to have, which is basically the right to keep and bear arms is a protected right that goes back with great legal scholarly study, okay? So these are a couple things that you can use to help you defend, okay? We need to understand that at the beginning of every one of these laws, there is an enabling clause that basically says how the law shall be brought into being. And there is an argument that the law that is presently here today is based on some law in the past, okay? And almost on every one of these constitutions, all the way up through our history, through the Articles of Confederation, through the U.S. Constitution, through various state constitutions, they'll have an enabling law in the beginning. And of course, the enabling law just allows them to bring their version of the Constitution of what rights are there today. The rights that were had before are carried on, plus are further delineated by this Constitution. But at no time do they have a right to abridge the previous document. Now, going all the way back to the Magna Carta, you can see the decisions where it comes down. The Magna Carta, the Declaration of Independence, the Articles of Confederation, the United States Constitution, the Virginia Acts of Concession, the Northwest Ordinance, the Northwest Territorial Government, the Northwest Territorial Division, Indiana, the Indiana-Michigan Territorial Division, the Enabling Acts, and that's what I'm trying to explain to you today. The Michigan Organization and Submitting Alternatives, and the Michigan Assent to Condition of Admission. And then the state of Michigan became a state in 1837. Now, this is just from my area, so I'm trying to give you an example. Then we have a Constitution of 1835. We have a Constitution of 1850. We have a Constitution of 1908. We have a Constitution of 1963. Every time one of these constitutions comes by, the enabling acts in the beginning of it state that everything that was before guaranteed is brought forward. Okay? So everything that is before is brought forward and carried forward, and if anything, it's supposed to be made stronger. Okay? It's never made weaker, it's made stronger, or it's equal to. So all of the rights brought forward are carried all the way back from the Magna Carta as a line of succession. So this is how you historically review trends and where, what, and how it comes from, and how authorities are established in law. Okay? The important thing to understand, we have our court cases here. We're going to start giving you examples of court cases as we go, and we're going to show you how you can exercise rights. Now, one of the first cases that we are going to bring is basically the right to travel. All right? Now, there's a lot of people that are interested in this particular issue, and license plates and driver's licenses and all this, and you have a lot of programming that's problematic from this, and you have a lot of people that are looking to argue. So we want to share some basic arguments with you. We're going to claim a First Amendment right to travel. And we're going to claim also a Fifth Amendment. It's guaranteed under the Fifth Amendment of due process and equal protection under the law. All right? Now, we come down, we looked up in our state constitution, and this is our constitution, and basically we have protected a right to travel. Okay? The freedom to travel is a fundamental right that should be unlimited by statutes, rules, or regulations which unreasonably burden or restrict movement. Okay? Now then, a law which substantially affects or penalizes the exercise of the right to travel may be justified only by a compelling state interest and must be tailored carefully to avoid unnecessary infringement on the right. Okay? Now, when we come down here, we start reading some of these arguments. You'll notice these little letters here that say, freedom to travel throughout the United States has long been recognized as a basic right under the federal Constitution. See Note 54. Everybody see this little Note 54 here? Again, we're going to take this Note 54. We're going to come down here. The very first case that we have is Shapiro versus Thompson. This is recorded at 394. That's volume 394. U.S., page 618. I just happen to have a copy of the case here. They're talking about the purpose of inhibiting migration by needy persons into a state is constitutionally impermissible. All right? All citizens must be free to travel throughout the United States uninhibited by statutes, rules, or regulations which unreasonably burden or restrict this movement. All right? If a law has no other purpose than to chill assertions of constitutional rights by penalizing those who choose to exercise them, it is patently unconstitutional. All right, does everybody pick up on the gist of the argument here? Equal Protection Clause prohibits apportionment of state services according to part tax contributions of its citizens. Any classification which serves to penalize the exercise of a right of interstate travel unless shown to be necessary to promote a compelling government interest is unconstitutional. Okay? Now, that's clearly established. Now, we go into the case, and we come to find out, it says that the right finds no explicit mention in the Constitution. This is what I was trying to tell you. You got to use a little bit of wisdom. You read between the lines. In other words, what is your right to life, liberty, and pursuit of happiness? Well, what does it mean to you? Think about it. You can look at the exact words. The right to life, liberty, and pursuit of happiness. Ducky, what's that mean? I have no idea. Well, I'm telling you to start having an idea. Because when you have an idea, they got to listen. So you have an idea and you say, I have a right to travel freely and unencumbered, right? Now, that a right so elementary was conceived from the beginning. They're talking about the right to travel. That a right was so elementary was conceived from the beginning to be necessary concomitant of the stronger union the Constitution created. In any event, freedom to travel throughout the United States has long been recognized as a basic right under the Constitution. We've established that the right is clearly there. So you were right. You had a feeling that you had a right to travel, and you were right. There is such a right there, okay? One of the ways you could find arguments on that would be to go into the Federal Digest at the local library, go down by your Supreme Court cases. There'll be a set of red books called the Federal Digest right next to the Shepard citations. You look up the book called Words and Phrases. And in the book Words and Phrases, you ask for the right to travel. It'll give you every Supreme Court case that has anything to do with the right to travel, okay? One of the leading cases is this case, Shapiro versus Thompson, that it's such a basic right it doesn't even need to be mentioned, okay? It is important that you be able to back your arguments up. In other words, it's one thing to pick the argument up. Now, here we go. In moving from jurisdiction to jurisdiction, they were exercising their constitutional right, and any classification which penalizes the exercise of the right, unless shown to be necessary to promote a compelling government interest, is unconstitutional, all right? Now, the reality was they exercised their right to timely travel, all right? And the state didn't want to allow that, all right? Now, let's flip back here. First of all, the Constitution is the supreme law of the land, right? We established that. Who said so? Marbury versus Madison, 5 U.S. 137, 1803. The Constitution of these United States is the supreme law of the land. Any law in conflict is null and void of law. Now, we know that the Constitution is supreme. We know that the right is clearly established in Shapiro versus Thompson. Can a state, arbitrarily and erroneously, convert a secured liberty, in this case the right to travel freely and unencumbered, into a privilege and issue a license and a fee for it? Obviously, we have decided that in Murdoch versus Pennsylvania, clearly, no state may convert a secured liberty into a privilege. Now, does everybody see how we plug that in? Just like on your computer, you fill in the blanks, okay? You have the court case. It says no state can convert the liberty into a privilege and issue a license and a fee for it. Well, what right are we talking about? The right to travel freely and unencumbered, so you plug that in. So does the state have a right to require you to have a license for the exercise of that right? No. Does everybody see that? Now, what happens if the state requires you to have the license? Shuttlesworth versus Birmingham, Alabama. You can ignore the license and engage in the right with impunity. That means they can't punish you. Now, what happens if they pull you over? They give you the ticket. Well, you're going to go to court and you're going to fight it. You're going to file a brief. We're going to show you how to do that at a later time. We'll show you exactly what to put down there. But these are the cases you're going to be putting down on your memorandum of law as to why you have a reason to feel that you're right. First, that your constitutional right is superior to any law that they would put down. You have that right, and they can't pass a law that takes away that right. Secondly, if they do, it's unconstitutional. Thirdly, no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, you can ignore the license and the fee and engage in a right with impunity. Shuttlesworth versus Birmingham, Alabama. And since you have not willfully done anything evil, you have relied on your Constitution and on the Supreme Court decisions, you have a perfect defense to the charge of willfulness. So you could not have been charged with willfully not going and getting the license. Does everybody see that? Okay? You have a perfect defense. United States versus Bishop, 412 U.S. 346. Defines willfulness as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. Obviously, you didn't do that, did you? Because you have a perfect defense. You relied on previous decisions of the Supreme Court, Shuttlesworth and Murdoch and Marbury. You relied on your constitutional right to travel freely and unencumbered, pursuant to Shapiro versus Thompson. So you have a perfect defense. So now where are we at? Your Honor, may it please the court, I motion for dismissal with prejudice, failure to state a cause of action for which relief can be granted, and I would like to motion to dismiss, and I'd like my costs and fees for having to defend this frivolous case. That you have a right to collect your time for going to court, all right? You submit your bill, you submit your proposed order, you fill out your own proposed order. That makes the case go faster, and the judges kind of like that. It intimidates the hell out of the prosecutor when you do your own order. Now, let's say, well, that's how you interpret that, sir. That's right, sir. That is how I interpret it. And 16th Am Jurisprudence 2nd, Section 97 says that it shall be interpreted in my favor because I am the clearly intended and expressly designated beneficiary to citizens for the protection of rights and property. See Briars versus United States, 273 U.S. 28. Unlawful, that deals with unlawful search and seizure, but it also deals that it's supposed to be interpreted in favor of you, the clearly intended and expressly designated beneficiary for the protection of your rights and property. So they got to enforce it in favor of you, right? Now, Boyd versus United States comes next. The court is to protect against any encroachment of constitutionally secured liberty. It's their duty. They have no choice. They have to do it. Okay? All right? In Norton versus Shelby County, an unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protections, it creates no office. It is in legal contemplation as inoperative though it had never been passed. Now, after you write all of this stuff down, you casually say, "Wherefore, Your Honor, I pray before this honorable court for your just and lawful relief. I ask that you dismiss this case with prejudice for failure to state a cause of action for which relief can be granted, and I pray the court for my just relief for having to defend this patently frivolous and spurious case, and my costs are whatever they are. You submit that on your order. I have an order. I have a proposed order, Your Honor. It's in my brief." At that point, they will turn to the prosecutor and say, "Well, Mr. Prosecutor, what do you think you'd like to do with this?" And most of the time, they're so overwhelmed at this point that they just go, "I'll go for the dismissal, Your Honor." And the judge will give them some slack. "Well, never before was a young man, not attorney, so literally overwhelmed when it comes for the prosecution, a licensed attorney." Now, it's not my goal to make attorneys look bad. My goal is to make you look good. My goal is to make you understand your Constitution. Now, if you happen to do it and you do it better than the attorney, God bless you. And God bless America. And if the attorney doesn't do his homework and prepare his case, I have no sympathy for him. Because he shouldn't have done what he was doing anyway. If he'd had any brains, he'd have pulled you aside and he'd have done what other attorneys have done to me and said, "You know, I hate going against a pro se litigant attorney." Almost always they're really, really good. And you know, I never get to find out if they're really, really good or they're really, really bad until I show up, and then it's too late. So I'm already on the diving board. And either the pool has water in it or it doesn't. And usually it doesn't. And it hurts when you hit the bottom. So they don't like going against you people. They will not like going against you. If you halfway know what the hell you're talking about, they're going to be intimidated. And I can tell you many, many, many tales. I had this one gentleman, he didn't have any plates on his car, and they called him into the court. And he was standing in the hallway, and the prosecution said, "Would you come over here, sir? I'd like to talk to you." He came in the office, and he sat down. And this party said to the prosecutor, "What can I do for you?" The prosecutor said, "Sir?" He said, "What can I do for you?" He said, "Well, it's not what you can do for me. I'm the prosecutor. What do you want to do in this case?" "Well, I assumed there was something I could do for you. You called me in here." "Well, what do you want to do? How do you want to plead on your case?" "Well, I don't intend to plead, sir. I intend to answer in the form of a demurrer, such that I do not acquiesce to quasi-jurisdiction, because that's an issue to be brought up in my pleadings and briefs to file with the court." The guy's mouth was on the ground. He said, "Are you an attorney, sir?" He says, "No, I'm a truck driver." The guy absolutely was in a panic. I had the same gentleman, later he was working as a bricklayer, and he did the same thing. Told the prosecutor he was a bricklayer, and the guy's jaw was on the ground. See, they don't anticipate that people that are in other jobs other than theirs have any brains. And it blows their doors off, and all of a sudden this bricklayer or this truck driver can come in and argue law, and all of a sudden it's like, shoot, this guy's good. I have to treat him like he's an attorney. So what did this guy do? The first thing he does out of the chute, he walks up to the judge and he tells the judge, he says, "Judge, I'm going to dismiss this case." Because he realized he was going to get hammered. And my guy says, "He can't do that. I took a day off work to come over here and battle." I told him, I said, "Shut up, sit down, relax, you won. Don't say nothing. You won." And the judge broke out laughing because this guy didn't want to quit. The judge turned to me and said, "Well, evidently the prosecutor doesn't want to proceed, sir. I'm going to have to dismiss the case. He is the complainant." "Can he do that, Judge? He can't do that. I'm here to battle. I want to go. Let's do it." And the judge laughed again. He says, well, apparently, sir, I cannot sustain a complaint that is not properly before the court. Counsel for prosecution has entered a motion to dismiss, and I have no other option but to dismiss. Now, if you want to countersue him, that's another case. Well, I'll do that. I'll do that. In the meantime, I told him, will you be quiet and submit your bill? Submit your bill. You won. Submit your bill for your damages. So he did. He said, well, I'll submit my bill, then, Your Honor, for my costs and fees for having to defend this frivolous case. And the judge smiled, because people don't usually do that. But if you win, they are required to pay you. That's the rules. If you lose, you pay. So the bottom line is this. When you file your papers and they turn around and you get a win, make sure you got your little bill in there for your lost time from work, or any copies that you had to make, or any visits to the law library, or any what's called real and personal damages. And don't pad the account. Put down exactly what you got, because if they force you to prove it, you can get busted for perjury. So I don't recommend you shall we say, stretch the pad. I recommend you put down exactly what your costs are. Believe me, the fact that they got beats plenty enough of a sting, and the fact they got to pay a couple $100 for your lost day at work will be more of a sting. And you will get a code on your license, and the next time you get pulled over, they will just hand your license back and tell you to think about slowing down and have a nice day. Because they don't like people like you. Because you're an American. Americans don't give up. They never surrender, and they fight. One judge told me one time, he said, you got any kind of idea how much money you cost this court today? And I said, I hope it was a bunch, Your Honor, because I hope you got to go write a whole bunch more tickets to break even. The way I figure, the more tickets you got to write, the sooner the public's going to wake up to this theft. And maybe they'll start doing something positive to stop this kind of stuff, because it's my belief they should be having masks on out there, because, I mean, if they was an honest crook, they'd be having a mask on there when they robbed the people. Okay? Well, he didn't like that answer too good, but the bottom line is he knew I was right, and after a while they realize what your goals are, and they know, hey, this is more fun than Edgewater Park, and I want to go on all the rides twice, you know what I mean? I want to hit the Wild Mouse and a whole bunch of them other rides. Let's do it. And see, when they see that, they realize there's no point. You're not going to learn anything. You're going to cost them time, money, materials. Now the system is not profitable. Okay? So they back off. They put a code on your license. They won't bother you anymore. And everybody see we take that line down. We take the line from the Constitution. We take the line from the right. Now let's think up another right. How about the right to work? Contract your labor and your skill and your time of life as you see fit. Now, your right to work is protected by the Constitution under the First Amendment. Again, you have a right to work and contract your labor and your skill and your time of life as you see fit. I get hauled into court before the chief judge of this big court here in Oakland County. I won't give you the judge's name because he was a fair judge and a good judge, and I'm going to let him slide. But the bottom line is this. He looked just like Abe Lincoln. I mean, exactly. He was the spitting image. And he leans over the chair and he says, well, he says, it's been reported to me, son, that you don't have a license to practice law. Is that correct? And I looked up at him and I said, Judge, I'm not practicing. I know what the hell I'm doing. And the whole court broke out laughing. He said, that's pretty good. That's pretty good. I like somebody with a sense of humor. He said, but that doesn't change anything, son. You have to have a license to practice law. And I said, Your Honor, I'm an unfranchised common law free man. I live at the common law. I am not a participant in any tontine schemes of limited liability on a joint venture for profit with an insurable interest requiring me to participate in these illegal corporate Ponzi schemes. I am just Joe Blow from Kokomo down on the street. I just live at the common law. And I have a right to work and contract my labor, my skill, and my time of life as I see fit, not as some third-party arbitrary and capricious bar association sees fit. And they had loaded the court with all these attorneys, and they were, whoa, you hear that guy? I said, Your Honor, the state of Michigan arbitrarily and erroneously converted my right to work into a privilege and issued a license and a fee for it. That's unconstitutional, Your Honor. Marbury v. Madison, 5 U.S. 137, 1803. Anything in conflict or repugnancy is null and void of law. Okay? Can you see that? Marbury v. Madison. And since the state converted my right into a privilege and issued a license and a fee for it, Murdoch v. Pennsylvania, no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth v. Birmingham, Alabama says I may ignore the license and the fee and engage in the right with impunity. That means you can't punish me. In U.S. v. Bishop, 412 U.S. 346 defines willfulness as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. I submit, Your Honor, I couldn't have done an evil task because I was totally following the Constitution in the U.S. Supreme Court. I would submit that prosecution counsel's burden is to prove that I did willfully and knowingly avoid a known duty or task under the law, namely to get the license. And I would submit he specifically precluded he cannot perform his task, and therefore I'd motion for dismissal with prejudice, failure to state a cause of action for which relief can be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous, spurious complaint. The judge rolls back in his chair with a great big smile, and he turns to counsel for the prosecution. He says, "Whoa, Mrs. Rose, what do you think we ought to do about this young gentleman?" The prosecution bounced back. "How about we honor the motion to dismiss, Your Honor?" The judge says, "Good answer, because I don't think you're ready for this kid today." And the whole court broke out laughing. An old gentleman walked up to me and he said, "Son, I just want to shake your hand and tell you, you got to have like King Kong, because you just slammed the Bar Association right into the ground." On top of that, I've been an attorney for 57 years, and I just want to shake your hand, sir, and tell you that that was one of the most magnificent arguments that I've ever had the privilege to hear in a court of law. Now, he was an honest attorney, and he realized what kind of a chain was around his ankle with this Bar Association. And these lawyers, they resent that. They really do. They're people just like you. They don't like to have any chains on them. But they hadn't had anybody quite show them how to get those chains off. And when they saw somebody do it in their own skill, with their own, with their own cards, on their own playing field, it actually impressed the hell out of them. I had several gentlemen come up and shake my hand that day. Needless to say, the case was dismissed, and I've been helping little people getting jammed for years. Every time I see some little person get jammed, I'm out there flipping that wrench. Zingy, zingy, zingy. And I flip that wrench on them so good, that usually they just back off. Dr. Kevorkian was a perfect example. The poor man was just trying to help these poor people. They were jamming him every which way but loose. So what we did is we taught him a thing called quo warranto. I got a hold of his attorney and submitted all of the arguments. All right, now we're going to bring up several arguments right here.
I really like how he shows you how to bring it all together and to have cases to refer to, and then also read it and be able to conquer almost any judge. And you're not there to shame anybody. You're trying to hold up your constitutional right, which these people usually do not know, and they're not going to help you. I also like the one about you traveling. You don't need a license. You don't need any of that stuff, but they're going to give you a lot of shit. I know some people, it's got podcasts where they're still getting harassed and they go back to court. But as long as you, if that's what you want to do, I would do it. And, you'll probably get in trouble. And maybe not, because I know when you do that stuff, you actually send letters to the police station, the judge, the prosecutor, and let them know, and even the DMV, you let them know the cases and where you're standing with the Constitution, because he shows right off where they cannot do that. It's totally unconstitutional, but because of the money, they keep doing it. And that's why everything in this whole system, and it's just not this, it's just all over the world, it's a system that is made to bring in money and take it from you. And I like how he said, they might as well put masks on because they're robbing people. He's telling the judge right to his face. Now, of course, you're going to have to read the Constitution. Get very familiar with it. And I would definitely refer from these videos that I'm putting up, and because there's different cases, different situations, and I got more to bring out, but I'm definitely going to be watching them 2 or 3, maybe more, and then I'm going to go to the law library and I'm going to get those books that he talked about. I'm gonna really start studying up so I can represent myself. But then if you get arrested, they tell you he tells you to play the fifth and lawyer up. So I think there's cases where you can't represent yourself. I'm not sure about that. I'd have to look into that farther. But the most important thing is to just know your constitutional rights, because the system is not set up for that. It's more of a scam system. And if you don't know your rights, they're going to take advantage of you. Hey, put thumbs up, give me a comment, subscribe, spread this. The only way we can spread this is to subscribe and like so the algorithm gets it out there. Love you guys. See you later.